Hello, everyone. My name is Steve Gann, and I'm your moderator for today's webinar, The Credit and Collection Environments of Central Eastern Europe. We have quite a large crowd in attendance today from around the globe, and I thank you all for being here. Today's webinar is sponsored by Bierens European Collection Attorneys. Bierens, established in 1952, is the oldest and largest commercial collection law firm in Europe. With a team of over 100 attorneys and staff, Bierens provides a one-stop shop model for your complete business-to-business debt recovery process throughout all of Europe. Before starting our webinar, let me take a moment to bring your attention to one item on the control panel on your screen. When you logged in and connected, a little control panel should have popped up on the right side of your computer screen. Towards the bottom of the control panel is where you can send in a question. As we'll be having the Q&A session after the presentation, please feel free to send in your questions along the way, and as best as possible, we'll try to get to all of them. Regarding today's presentation materials, please contact us afterwards, and we'll be happy to email them out to you. Now, let me take a moment to briefly introduce each of our presenters. Mr. Georgi Georgiev received his master's degree in law from the Southwest University in Bulgaria, specializing in commercial law, private international law, and insolvency. During his studies, Mr. Georgiev completed a number of legal internships for private organizations in Bulgaria and several business internships in the U.S. Within Bierens, Mr. Georgiev is responsible for all commercial and legal matters as they pertain to Bulgaria. Dr. David Mazaros studied law at the University of Vienna and concurrently at the ELTA University in Hungary. Dr. Mazaros' concentration is on private international law, international commercial law, and cross-border mergers and acquisitions. Dr. Mazaros has several years of legal experience working for law firms and organizations in Hungary, Austria, and the United Kingdom. He is responsible for managing the Hungarian desk within Bierens. Mr. Tadej Francel obtained his bachelor's in law from the University of Ljubljana, where he is now continuing with his PhD studies, writing his thesis in the area of corporate law. Prior to joining Bierens, Mr. Francel worked at Slovenia's largest insurance company. At Bierens, he is responsible for and managing the Slovenian legal desk. To all the attendees today, we're going to shut off our webcams while the presentation is being given. And so with that, let's get started. Tadej, you're the first batter up. Let's take it away.
Good afternoon, everyone. My name is Tadej Francel, and I'm an attorney with Bierens Group, where I'm in charge of our clients' commercial and legal matters in Slovenia and in some of the ex-Yugoslavian countries. It's a pleasure to have an opportunity to speak with all of you today, and I will try to make it as informative and practical as possible. Let's start the presentation with a brief country profile. Having its capital in Ljubljana, Slovenia population is around 2 million. The BDP of Slovenia in 2015 was 62.5 billion US dollars. According to Slovenian Minister for Finance and according to market charts, which are rising again compared to last few years, when the period of crisis was, this is now ending. Slovenia is parliamentary democracy, which means that the president has very limited powers, while Parliament is the one who's taking most of the important decisions. Slovenia adopted euro as a currency in 2007 and is member of EU since 2004, member of ASEAN since 1992, and member of NATO since 2004. Crisis in Slovenia was not bad only for economy but also politics. Since the start of the crisis in 2008, we had 4 different parties won the elections, although normally we have elections every 4 years. In 2014, the last parliamentary elections were held, and a newly established party, SMC, won as they received 34.49% of the vote. Leader of this party and currently Prime Minister of Slovenia is a former professor at Faculty of Law, University of Ljubljana, Miro Cerar. Since 2012, President of Slovenia is Borut Pahor, who was also Prime Minister from 2008 to 2012. There were several corruption scandals in a short Slovenian history. For the last few years, Slovenia has also been known as a country with one of the highest percentage of managers, among whom corruption is very common, 96% based on research done by Ernst & Young in 2013. The situation is improving, but there is still too much corruption. Reasons for corruption are bad management, lack of transparency when adopting legislation, lobbying, and wrong moves by a Ministry of Justice. Let's move on the Slovenian economy. As I already stated, economic crisis in 2008 hit Slovenia hard. The government was forced to make cuts, which were most visible in wages and pensions. The real estate market collapsed and has only lately reborn. It is, however, still difficult, for example, to get a bank credit, but banks are prepared to help people more and more, and also real estate prices are rising again. We can see that from the current situation, as again, most wanted are small apartments in Ljubljana, as they are kind of investment because they are easy to rent, so people are prepared to invest their money again. Now let's focus on Slovenian legal system. Slovenia has civil legal system. Slovenia has general courts and specialized courts. General courts are handling criminal and civil cases. It has three instances, where first instance is divided on district and regional court, second instance is higher court, and last one is Supreme Court. We also have a constitutional court, which is only dealing with cases when the question whether an act or a judgment is according to the constitution arises. Slovenia has also arbitration center, which has general power, control and power of decision over litigation between legal entities. If you have an enforceable title, you need to go to a bailiff, who will enforce it for you, as you cannot do it on your own. You can find bailiff on the website of the Chamber of Slovenia. When you do not find a debtor, or you are not sure about his assets, you can hire a private detective. You can find it online. They are limited by the special law. The price is not determined. Law only advises what the price should be. When we go to court, the best thing is to have all of the following documents: contract, invoice, shipment document showing the signature of the authorized person and the debtor's corporate seal, demand letter, notification that the demand letter was sent out, power of attorney. Let's talk about the court proceedings now. Court proceedings are different than what we are normally used to. When you file a lawsuit, court will send it to the opposite client defendant, who can answer. The defendant's answer will be then sent to the applicant, and this process will go on as long as the court will decide it is enough and decision can be taken or hearing can be scheduled. Where the claim is about the debt and you enclose an authentic document which needs to be original or certified copy, the court shall order the defendant to honor the claim. The payment order is issued without a hearing by official of the court. Normally, the defendant needs to pay the amount in 8 days or object the order. When court do not issue an order of payment, it will proceed with normal proceeding. Also in Slovenia, we have a procedure for small claim below 2,000. Moving on with ordinary proceeding and court system. Legal action needs to be brought before the court at the location where the defendant is living. As I said, at the first instance, we have district and regional court. If the amount is below 20,000 euros or the law has determined so, the district court will handle the case. Here we have a diagram how the court system in Slovenia looks like. Further on, I would like to provide some main information about interest rates in Slovenia. Interest rate is determined by the Ministry of Finance twice per year. From 1st of January 2017, it's 8% annually. Interest on interest, compound interest, are prohibited by Slovenian law. Also, interest cannot be higher than the principal amount. Just for information, some sectors have from 15 up to 19 days payment standard in practice. In general, the law regulates cost of a lawyer and a court. Normally, they charge between normally lawyers charge between 300 and 500 euros, or you can also agree on around 10% of the claim. When collection is made through court proceeding, the creditor has the right to ask the court to reimburse the cost. The court will award the cost if the decision is in favor to the creditor. But court can also reimburse less cost. In case when party only won like 80% of the case, also cost will be normally divided so. When debtor owns not only principal amount but also cost and interest, the first thing paid are costs, then interest, and then the last one, the principal amount. Now let's talk about the bankruptcy procedure. When you file for a bankruptcy, it's good to have following documents: contract, invoice, shipment document showing the signature of the authorized person and the debtor's corporate seal, statement of the balance due, notification of the debt due, power of attorney, and court title, if you have any. Proposal for the bankruptcy needs to be sent to the court. Court decide whether bankruptcy procedure should start. Persons eligible to file a proposal for bankruptcy are the debtor, personal liable shareholder of the debtor, the creditor. He needs to prove his claim against the debtor, and also that the debtor is late with the payment for more than 2 months. Public Guarantee, Maintenance and Disability Fund of the Republic of Slovenia. They need to prove employees' claim against the debtor and also that the payment is due more than 2 months. After bankruptcy started, debtors have 3 months to register their claim. The standard procedure can take from 1 year up to 3 to 4 years. Now I'm going to pass my presentation to my colleague, Georgi Georgiev.
Thank you today, and thank you, Stephen, for the kind introduction. Good afternoon, everyone. My name is George Georgiev, and I'm an associate with Bierens Group. And as Stephen stated, I'm in charge of our client's commercial and legal matters in Bulgaria. In my presentation, I have emphasized on a few political, economical, and judicial updates and details, which I think will be of help to you when it comes to drawing clearer and better picture of what to expect when doing business in Bulgaria. Let me start with a brief country profile. The capital is Sofia, and the population is 7.2 million. Bulgaria is a member of the European Union and almost every major international convention. Bulgarian's currency is lev, tied to the euro, with an exchange rate of 1.95 lev for 1 euro. But you may want to note that the Bulgarian lev is fluctuating towards the dollar, with a current rate of 1.74 lev for $1. But the most interesting thing on this slide for our audience, I think, will be the mentioning of the corporate tax percentage. As you can see, it amounts to only 10%, which makes it the lowest in the whole European Union. Moving forward with an update over the political situation in the country, I think it's safe to say that in the last few years, the country's political scene suffered some hectic moments. The elections originally scheduled for 2018 were held primarily in March 2017, following the resignation of our Prime Minister Boyko Borisov and the failure of the Bulgarian parties to form a government. Following those elections, Boyko Borisov became Prime Minister again for the 3rd time, while those were the 3rd elections in the last 4 years. Probably many of you are wondering how this political instability has influenced the economy. Well, moving forward with the next slide, I want to draw your attention to the economic growth line, which gives us a clear picture how the economy is handling those domestic political crises. As you can see, not too bad. The GDP growth percentage is rising, reaching the stable 3.4% for 2016, and according to financial stats, it should stay the same in 2017. I'm sorry for the bit of inconvenience, but the internet is a little bit slow. Moving forward with the presentation, I want to help you understand the basis of the Bulgarian civil law system, since I'm sure for our audience from the United States and United Kingdom that comes from Anglo-Saxon legal system may be quite confusing. The important thing that you should remember from that 4-step pyramid you see on the slide is that you always have three-instance core system, and depending on the amount of the claim, your first instance will be either regional court or district court. If your claim amounts to less than 12,500 euro, your first instance will be regional court. But if it's above the mentioned sum, the lawyer files your claim in front of the district court. And when we start talking about filing claims in front of the court, there's three questions arise. What percentage of interest is applicable? Can I ask for collection costs incurred before filing the claim? And what type of court proceedings are on my disposal? When it comes to interest rates in Bulgaria, the percentage you should mind is the state-regulated 10%. And the fact that compound interest in civil contracting is prohibited, although when it comes to contract relations between traders, compound interest is allowed. I want to bring your attention to the last point. When it comes to disproportionate interest, although it may be agreed upon, the court has the right to diminish the percentage to the state-regulated 10% if it feels it's in the best interest of the both parties. While in regards to collection costs, the ones incurred in the amicable phase cannot be asked in front of the court, only the ones made during the judicial process, such as lawyers and court fees. The court procedures you should always consider is if your claim amounts up to 12,500 euro is fast civil proceedings. Starting this procedure, you can reach an enforceable court judgment in roughly 2 months' time. But you should mind that with a simple opposition from your counterparty, the court process shifts to ordinary civil proceedings. In the next slide, I have prepared a list of documents that you may want to have before starting legal proceedings. As I presume you are familiar with most of them, I want to emphasize on one in particular, the power of attorney. It has to be signed by the competent representative of the company and sent in its original version and signatures by mail to your lawyer or to the court. And we cannot talk about court procedures without mentioning the time limitations that are guarding your right to ask for what is owed to you. Time limitations according to Bulgarian law is 5 years from the invoicing date or the day the amount went due. I'm sure many of you, of our guest listeners today, are wondering if you can seize or freeze counterparties' bank accounts or assets. Yes, we can, but only with an order from court of law. In regards to how long can the whole legal process take, I cannot give you an exact time frame. It depends on the case complexity and the asset liquidity of the counterparty. The general time frame is 3 to 4 months of court proceedings, while enforceable judgment is reached, and another 3 months of enforcing it. And while reaching the conclusion of the litigation part of my presentation, I think it's important to mention how much can it cost, as it varies again with the complexity of the case and the time needed. Lawyers' fees are hard to determine, but when it comes to court fees, the general frame is 2% of the claim's principal amount for fast civil proceedings and 4% of the claim's principal amount for ordinary civil proceedings. But please note that other expenses are very likely to appear. As a final point in my presentation, I want to shed some light over the bankruptcy proceedings in Bulgaria. Although it's quite time, effort, and fund demanding, we cannot overstep it. What I want you to remember from the slide is that insolvency proceedings in Bulgaria is court-administered process divided into 2 stages: debt restructuring with company revival and liquidation of assets. If court deems that a revival is possible, he will proceed with this option rather than liquidating the assets and estates of the company the company has. The other important point from the bankruptcy proceedings is the priority rule. For you to be a priority creditor, you would have to have securitized your debt with a specific estate or asset of the debtor. If you have done that in your initial contracting, then yes, you are eligible to be classified as priority one. If not, you have to follow the process chain. And with this, my presentation comes to an end, and I'm passing the ball to my colleague David Nazaros.
Thank you very much, Georgie. Good afternoon. My name is Dr. David Mészáros. I'm an associate responsible for the Hungarian desk at Bierens. Following the example of my learned colleagues, I would like to start by giving a quick country profile. Hungary has an economy tilting heavily towards export with a profound accent on foreign trade. As you can see, the GDP is 284.3 billion. However, it should be noted that this is PP, as in purchase power GDP. The nominal is about 125. Consequently, the country is the 36th largest export economy in the world. In Hungary, the business culture can be divided into two different segments. First of all, we can talk about the traditional Hungarian business atmosphere, if such a thing even exists, where people usually interact only with their associates and with their closest network. This is usually the case in every part of Hungary except for Budapest. It must be noted, though, that out of the 10 million Hungarians, roughly 3 million either reside or do business in the Budapest metropolitan area. This means that the country is incredibly centralized and that business life almost entirely takes place in Budapest. Such as tenders, big projects, all the serious law firms and companies are registered and operate mostly in or out of Budapest. From a legal or banking point of view, most likely as well debt collection point of view, this also means that the authorities, banks, and the courts in the capital are encumbered. The capital is greatly influenced by international companies and organizations. Traces of globalization can be found. As you can see, our currency is the Hungarian forint. You might want to be aware of this, as our interest rates vary based upon the rating of the the Hungarian National Bank, and not that of the European Central Bank, which is, of course, for the euro. Justice in Hungary is administered at 5 different types of courts. 1 second, just a small technical issue. Yes. Justice in Hungary is administered at 5 different types of courts, but 7 different types of functions regarding these courts. The first and foremost is the district court, which can be found in almost every major city. This is a court in first instance. Should you ever initiate legal proceedings in the country, this is most likely the place to start. I say most likely because depending on the amount and the origin of your claim, it might either belong to this court or the regional courts. The second important group consists of the administrative and labor courts. This is a joint court which handles both administrative and labor law matters simultaneously. There are 20 of them, so 1 per region and the capital. A small step up from the aforementioned 2 are the regional courts. They're established the same way as, but not alongside, the administrative and labor courts, meaning that there are 19 in the region, so 1 per region, and 1 in the capital. This is a court where it gets a little tricky. These function as courts in the first instance in certain cases defined by law. However, they are also the appellate courts of the aforementioned 2 in certain cases. If your case is very complex and we need to appeal, then we have to turn to the courts of appeal and eventually the Curia, which stands for at the top of the hierarchy. This is the Supreme Court of Hungary. Besides appellate cases, they also render uniformity decisions in cases raising issues of theoretical importance in order to ensure the uniform application of law within the Hungarian judiciary. Such decisions are binding on all Hungarian courts. Naturally, we can talk about legal interest and standard regulation by law. However, it should be emphasized that contractual agreements on interests, damages, and such supersede this, allowing parties to set a more desirable percentage. The only obstacle parties face when agreeing on such conditions is that their agreement on the interest should not constitute a usury interest, which would render it null and void. The limitation period is generally 5 years, which starts with the due date of the claim. Complementary claims are connected to the main claim. After limitation, a debt cannot be claimed in court. However, this does not mean that the claim ceases to exist in the eyes of the law. It simply becomes a naturalis obligatio. The limitation period may only be interrupted with official legal action, such as a payment ordinance, a lawsuit, or enforcement, and so on. We do not have special laws regarding extrajudicial debt collection. The Directive 2011/7/EU on combating late payment in commercial transactions is applicable since we are talking about an EU member state. As for the legal proceedings that you can make use of, the order for payment procedure, this is the national equivalent of the European order for payment, which you might be familiar with. The defendant may make a statement of opposition to the order for payment to the civil law notary, so not to the court, within 15 days of its service. Applications submitted by the defendant simply for deferral of payment or payment in installments are not considered as a challenge to the order of payment. The notary's proceedings, as out-of-court civil law proceedings, have the same effect as court proceedings. The statement of opposition automatically starts a regular civil lawsuit. If an order for payment is not challenged by a statement of opposition before the deadline, it will have the same effect as a final court judgment. As for the regular civil procedures, no form is provided for the submission of applications instituting the proceedings, but for order for payment procedures preceding such applications, falling within the competence of civil law notaries, a form is available on the homepage of the Hungarian Chamber of Civil Law Notaries and in notaries' offices. And another important point to make is the enforcement in Hungary is a civil, non-litigious procedure through which the state exercises the fulfillment of obligations included in the country in a court and notary decisions and other documents defined by law by applying coercive measures. Bankruptcy proceedings, the definition is very important here. Almost every word is very important to note. The firm is insolvent if it cannot pay off its debts in 60 days after the date of maturity, and it is stated by court. Now, we do have two different groups here, two big groups within which there are also several subsegments. So the bankruptcy and the liquidation. As you can see, it can be voluntary or involuntary, and the liquidation ends with the closing of the firm. In more details on the next slide. With the bankruptcy procedure, it starts with the debtor's notification. A trustee is assigned. Creditors will claim their debt to both the debtor and the trustee and will gain voting rights for the registered claims. The moratorium, first 90 days guaranteed, can be extended. The extension of the 120 days moratorium that can be expanded again to 240 and 365 days in special cases, or the bankruptcy agreement may be signed. During this moratorium, the debtor and the creditor must reach an agreement for the recovery, or the debtor must meet the creditor's demands. In case of no success, liquidation starts. But the liquidation procedure, it must be noted that it can be started by both the creditor and the debtor, hence the voluntary and involuntary nature of it, or an order of a court. Hereby, a liquidator is appointed. He acts as the CEO of the company. He oversees pending contracts and transactions. 40 days to announce a claim to the liquidator. Afterwards, there is a ranking of the claim. It depends on the origin of the claim. It has to be noted that liens and mortgages and other pledges have priority over other claims. After selling the properties of the debtor, a final balance is prepared. Naturally, within 30 days, you can raise an objection against the final balance in case some of your debts, assets, and so on have been over or undervalued. And it ends up with the closing of the firm. A gray area, but has to be mentioned, is the final settlement of companies. It's not an insolvency. It's not supported by legal framework. However, it exists and it can be made use of. And that will be all for Hungary. Thank you very much.
Thank you very much. And that was a very informative overview of the legal environments in your respective countries. And let's turn on our webcams, and we will continue with the panel discussion. Great. We have quite a few questions on the line, and let me start with the first one. Are there banking and overseas remittance restrictions within your country? Tadej, why don't you start with that one?
In Slovenia, we don't have any restrictions about transferring in a banking system.
Georgie, any thoughts on that?
Hi, Steve. Thanks for the question. First, no, I specifically checked all the restrictions that we may have towards, respectively, US and UK, and there's none. Okay.
David, what are your thoughts?
In Hungary, there are certain restrictions. What should be noted is that the bank can accept incoming remittance in forints, euros, USDs, or Swiss francs. Customers can also apply to remit to the beneficiary within Hungary. Now, about the characteristics, there are two options for outgoing remittance: normal remittance and urgent remittance for foreign currencies. In case of forints, the normal remittance applies. It is managed through Giro, and the urgent ones are managed through Viber.
Very good. Here's our next question. It says here, in my country, Brazil, I can freeze a bank account without a judgment, but I need to put up a bond if I'm going to take this kind of action. Then I can proceed with an emergency or urgent court case. Is there something similar to this in your country?
I may start. In
Yes.
Hungary, there is no special rules regarding a freeze of assets or a bank freeze. However, as I mentioned, we are a member state in the European Union, and as such, the regulation 655/2014 applies. It is a European account preservation order procedure. It's to facilitate cross-border debt recovery in civil matters. Now, this established a union procedure enabling a creditor to obtain a European account preservation order, or just order, which prevents the subsequent enforcement of a creditor's claim from being basically jeopardized through the transfer or withdrawal of funds. It has to be noted that there's a certain limit, so up to the limit that you can prove your claim's existence, you can request for the issuance of such an order. But above that limit, the debtor is free to move his assets or his money.
I see. Tadej, do you want to chime in on that?
Yeah, so as we are also in the European Union, situation for cross-border, it's the same like in Hungary. But I would like to say, if you want to freeze assets, like if you're from Slovenia or in Europe, it's like first you need to go to court. You need to ask court for permission, and when you get the court permission, then you can freeze assets. You cannot just do it without the court.
Okay, so you need a judgment then.
Georgie, or not just a judgment, but also just a court permission. It doesn't need to. You can do it also in the middle of the process. You can ask for a court to just to do it as a safety, you know.
Okay, Georgie, how about in Bulgaria? The same as my colleagues, the same as Slovenia and Hungary. The new European regulation applies to Bulgaria also. But as today stated, in Bulgaria, also you cannot freeze or seize bank accounts without permission from the court. So that means that you either have to exercise your right given by the European Union with this new regulation, or you have to start the court procedure and ask the judge to issue an order, not a verdict, but an order on seizing the debtor's accounts and assets.
One more thing just occurred to me regarding this topic. It is a very new thing, and there is not really much practice on the subject matter yet, since it was implemented on the 17th of January this year. However, it is already clear that you cannot request the issuance of such an order in arbitration. So if you have an arbitration clause with your counterparties, then you have to be aware of this, as well as if the company has already went into bankruptcy and claims originating from employment, so labor law.
Very good. Here's our next question. Is it necessary for the creditor to be a witness in court on a case that is being sued and disputed? Can they designate someone to represent them? And I think that question has to do with the idea that an overseas creditor, if you have a creditor here in the US, it would probably be a little difficult for them to make the trip over to Slovenia. So is it necessary for an overseas creditor to be a witness in a court on a case that is being sued and disputed? Tadej, why don't you take a stab at that?
Yeah, so for overseas, I can say that normally court would also accept the statement, like written statement, or maybe they will do it over the conference call. Because if the technical, if there are like technical things that they are like you have computer, you have a web camera and everything, and you can do like conference call, then they would also probably accept that. But if they don't have it, they would also accept the written statement. But if I would like just to add, if that's not in overseas, it's like if debtor is in Slovenia and also creditor is in Slovenia and court procedure is in Slovenia, then a witness needs to go to court, and only if it has like some kind of excuse, which is very, I don't know, like problem with health or it's in hospital or whatever, then it can be excused. Otherwise, it needs to go to court. Otherwise, court can send out a warrant to arrest him and bring him to court.
Very good. Georgie, do you want to chime in on that?
Of course. With a simple petition from the side of either claimant or creditor, he can be excused from court hearing if he is represented fully by his lawyer, and with just a simple statement to the court stating the reasons why he cannot be present at the court hearing, there won't be any problem with him not being present in the court room. Yeah.
David?
Well, just like they said, if you have a legal representative, a lawyer who's handling your case, then you can just send him to act on your behalf. That's why it has been stressed, and that's why it's so important to have a signed and stamped power of attorney given to your proxy. Another option would be to send a signed affidavit, sort of a witness statement. However, I would say that if the case gets way too complex, then the court might deem it crucial for the party to be present, but that's, of course, the minority of the cases.
Okay, very good. Here's our next question. In my country, we have a very well-developed arbitration system. Instead of a suit, which requires a long, drawn-out legal process, is there a formal arbitration or dispute resolution system in your country that will expedite the legal process? Georgie, why don't we start with you?
In Bulgaria, as a member state in the New York Convention of Arbitration, since '54, we are fully prepared to execute and to be handling cases in our arbitration court. Over our arbitration court, probably per year, are going thousands and thousands of international cases. And I can say easily that it's way more fast and even better for our clients if they actually have arbitration clause in their contract.
Okay.
In Slovenia, we often see the clause in contract too. So a party doesn't want a court to intervene, but they want to go to solve the case in front of arbitration. Because of that, we have arbitration center in Ljubljana, and it's handling all the arbitration cases, mostly all of them.
David?
Well, in Budapest, besides the Hungarian Chamber of Commerce, we have an operating arbitration. However, I must say this is just a personal experience. I've never really seen it put to use. At least I never had the chance to go there and use it. But I must say that there are two other really good alternatives, or maybe prior options. One is our neighbor country in Austria. It's the Vienna Commercial Arbitration, which is very good and relatively cheap. And the bigger one in France is the ICC, but I wouldn't recommend it because it's way too expensive. For a claim of about 150 to 200,000 euros, you would have to pay 30, 40K, depending on the number of the arbitrators.
I think all three of you had mentioned this in your presentation, but generally speaking, what is the time frame if somebody initiates a suit, a commercial suit, and there is no dispute from the time that the suit is commenced until the time the judgment is rendered? Is it less than 1 year? Is it less than 6 months? I think you had mentioned this in your presentations, but let's just go across the board and kind of recap that a little bit. Georgie, go ahead.
It depends on the procedure, as I stated in my presentation. If you take the road on passive proceedings, you can reach enforceable judgment in the short period of even a month if it's not if your debtor didn't oppose. But if the procedure shifts to ordinary civil proceedings, mm-hmm. If it's not objected, let's say 2 or 3 times, you can reach an enforceable judgment in 6 to 1 year, from 6 months to 1 year period of time.
Okay.
I would say that in Slovenia, if the defendant doesn't object, then you can get the judgment in half a year. Otherwise, it takes a long. Like I said, in Slovenia, we have different system. It's like when a court gets a lawsuit, first he checks the lawsuit, and after that he send it to defendant, and then defendant has some time to respond. and then this goes on and on. So it can take also like half of the year just these answers are going from one client to another, and because of that, also process is taking like for a year or even more.
Okay, David.
Well, like I mentioned, in the case of order for payment procedure, there is a given set of days. It's 15 days, but they will most likely object because it is very easy to object. You just have to tick in a box. You don't even have to present a formal defense. You just have to say the magic words, yes, I object to it, I contest the claim. After that, with the regular civil proceedings, just like with my learned colleagues, it really depends. If it's a smaller claim, a relatively simple case, well documented, signed by both parties, CRM, every document is present, then I would say a couple of months. But depending on the judge, depending on the parties, the reactions of the counterparty, it can drag out to a year or two.
Okay, thank you. Here's our next question. Excuse me. Is there a main lawsuit registry where any lawsuit filed against a company can be easily seen as a public record? For example, if I wanted to do business with a new company in Slovenia as part of the public record, would I be able to find any lawsuits that are in progress or that have been completed with a judgment on that particular customer? Tadej?
So I would like to say in Slovenia we have a register of already judgments, so we can read every judgment which was already so it was already taken, and also you can what you can do is go on the court list on the website. You can see all the process which are ongoing. You cannot you cannot search by a lawsuit, but you can go on the website of the court and you can see all the process which are ongoing. That's possible, but not about to check search with the lawsuit.
So if you were to search by the company name in Slovenia, would it come up?
So what you need to do is go on the website, and basically what you do normally, you just type keywords, like keywords of the case, I don't know, debt collection, and then you see all the cases, and you can then you need to search, and sometimes you can even find by the company name. Yes.
David?
Just like in Slovenia, we also have public records of past cases. As a rule of thumb, the lawsuits in Hungary are of public nature, so you can attend them, you can see them. However, some parties ask for them to be anonymized, and then you can't access the names, the most important information. We do not have like a registry, like a record on ongoing litigations. However, we have a company registry in which you can search for the designated company that you're interested in. And if it does have one of the three following endings, so CA, FA, or VA, then it means that they are under some sort of bankruptcy or insolvency procedure, which is an indication already that you shouldn't do business with them or shouldn't invest, or you should immediately lodge your claim.
Georgie, how about in Bulgaria?
Well, Stephen, in Bulgaria we don't have a public record when it comes to ongoing judicial processes. But we do have for already existing given court judgment. You can easily find if a company has obtained a court judgment with a simple Google search. Those registries are kept in the websites of the respected courts around Bulgaria. But as to ongoing cases, I'm afraid we are not able to see that. We can only see if the company is put under insolvency or is going under restructuring. This we are able to see. Rather than that, we are quite limited.
I would also like to add that in Slovenia, you can also check the registry of the companies, and there you can see if the company is in bankruptcy procedure or liquidation. It's saying next to the name in a bankruptcy procedure or in liquidation. You can also see that, but you need to have access to company register, so you need to sign up for it.
Very good. We do have another question. Like we have with Dun & Bradstreet in the U.S., are there any specific credit rating agencies, or credit reporting companies, providers in Europe? So I'm assuming, D&B is probably very prevalent in your countries. Besides D&B, is there a specific or a national credit reporting or credit rating agency in your countries? Georgie, let's start with you.
While we are talking about Dun & Bradstreet, I managed to see that they're with a close relation to a Bulgarian organization called ECAP, with which they are working, and I saw that they're very well established on the market. So in respect to that, yes, they are very well established on the Bulgarian market.
Okay, Tadej?
So in Slovenia we have some national agencies which provide the report. You can also find it online, or when you access the corporate registry, you can find advertise. They're advertising that they can send you a report of the company for a certain price.
I see. David, how about in Hungary?
In Hungary, we have several companies. I would like to just mention one without any hidden purpose of commercialism. It's the Opten that I like to use. And Europe-wide, we are collaborating with CreditSafe, which gives us these credit records and background checks. And there was one other that I wanted to, as the others were talking, CreditSafe and Opten. Oh, yes. And we have the Europe-wide organization of credit control, credit management, and debt collection, the FENCA. And the local branch of that in Hungary is called Makis.
I see. Okay. Which leads us to our next question. Similar to the US and Western Europe, is there a collection industry in each of your countries? For example, are there laws that regulate collection activities such as the Fair Debt Collection Practices Act in the US? David, let's start back with you.
In Hungary, a lot of things, but really a lot of things pertaining to commercial activities are regulated by the civil code. Besides that, we of course have a code for insolvency. But other than that, we do not have special laws, special acts regulating that collection. We do have some regulations for some certain stamp duties and smaller regulations, but as a whole, we do not have something that we would call a debt collection law. However, in Europe, like I mentioned in my presentation, we have a directive. It is on the combating of late payment in commercial transactions, and it is active in the whole of Europe in every member state. What should be noted perhaps here, I think one of the most important points is that Article 6 says that a minimum of 40 euros can be awarded as reimbursement for the creditor. A lot of debtors love to see it as the reimbursement, so 40 euros, but the law actually says that it is the bare minimum, and the collection agencies' costs or lawyer costs are in addition to that.
So you've mentioned collection agencies. About how many collection agencies and how many lawyers are specializing in debt collection within Hungary? Just in a broad.
Collection agencies, quite a few. I would say there are at least 20, 25 really strong ones who are present on the market. Okay. Of course, the international ones that are very well known throughout Europe and maybe even US. I'm not too familiar with that. However, law firms that are specifically designated in debt collection, so somebody just like Bierens who can take you from from A to Z, so as a one-stop shop for debt collection, there are very few, if there are any.
Okay. Georgie, what about Bulgaria? What's the collection industry like? How many collection attorneys? How many collection agencies? And are there collection laws in your country?
Well, Stephen, to not repeat what my colleague just said, we are a civil law guarded country, and we are regulating ourselves by the civil law, and there's sadly no debt collection law applicable in the country. While when it comes to debt collection specialists and how many are they existing? Yes, lots of lawyers are executing debt collection, but it's only a minor part of their main duties. Let's put it this way. So you can see lots of lawyers doing labor or civil or marital law, but on the side, just to keep it on a float, they would do debt collection. So like my colleague stated, one-stop shop as Bierens do not exactly exist in my country, and to my knowledge in probably the whole Balkans.
Very good. Tadej, collection attorneys, collection agencies, collection laws in Slovenia?
So in Slovenia, there is no special law just about debt collection. Like my colleague says, like in Slovenia, everything is determined by civil law. About, like I said, about attorney's fees in attorney's law, and about court fee in law about court fees. So you need to check all these these laws. And about debt collection agencies, I did the research, and there are several agencies. You have, I would say, between 10 and 15, biggest one, and then you have some smaller one, of course. And out of this, like maybe 10, it's an international one, but they're not pretty good or something. It's also about law offices. It's similar situation. In Slovenia, there is no law office like Bierens is. There is no law office who would just do debt collection. They all do other stuff, and as a side business, they also do debt collection, but nothing like Bierens.
Very good. Here's our next question. It's a rather long question. As our company sells special solar-based energy equipment that is installed into a structure, is it possible to file a mechanics lien against the property where the equipment that is installed becomes a permanent part of the structure? Is it possible to initiate a foreclosure against a foreclosure proceeding on the property where you have a valid lien? Tadej, why don't we start with you?
So first here I would ask a question if this solar panel is removable or not. Because if it's removable and you don't damage a house or construction or wherever this panel is fixed, then you cannot, then it's not part of the house, and then you can just have a claim on this, on the solar panel. If it's part of the house and you cannot remove it without any damage, then of course you have claim over the house also. It's combined. But in your claim, it's what the difference is between the price before you put the solar panel on and the price after that. So the difference, the price rise.
Okay, David.
Well, there is no such thing as a mechanics lien, but there is a legal framework for example, for retention of title, and as well as we can sort of call it a statutory lien. What we have. Whereby the contractor shall be entitled to a statutory lien up to the contract price and the expenses on the property of which this customer gained the possession in consequence of the works of the contract. The biggest question one has to ask is whether the builder, the contractor, acted in good faith or bad faith. Because if it acted in bad faith, then all damages, all costs have to be borne by the debtor, or, well, in this case, the contractor, the builder. If not, then a similar situation arises, as Tadej explained. It's a bit similar to the legal institution of encroachment regarding property. So,
okay. Georgie, are mechanics liens a legal mechanism in Bulgaria?
No, Stephen, we don't have a mechanic lien in our civil law system. We may tie it a little bit better with retention of title, but when it comes to permanent structure, as you said, as my colleague already stated, it's it's very important if it's in good or bad faith. Also, it's very important when it comes to the contracting of the whole deal. If the debtor is personally liable or is not, for what is he personally liable. But going into foreclosure, this is a bit too big of a stretch for Bulgarian law, because you see in countries like Bulgaria, the population owns 90% of the population owns its own homes, and they're very well protected. If it's not specifically agreed that he may be liable with his personal assets and estate towards the completion of the contract, yes, you may foreclose the property and liquidate it, but otherwise I don't see how I don't think that it will go so far.
There's another matter that I'd like to add. I just thought about it as Georgie was explaining his point of view. There is also a special regulation regarding unlawful enrichment. There's much loose talk in our legal systems about this, because let's imagine such a legal situation, such a business relationship between the parties, and as a result of such, as a result of such a foreclosure, the original contractor would get more money or more benefits out of it than he invested in it. And that's why in Europe we have the principle of nemo plus juris, that you cannot get more rights than you already invested into it.
Okay, we're coming up to the hour. We have time for one more question. In the U.S., a countersuit is sometimes used as a strategy to thwart a creditor's suit or force a creditor to accept a much smaller settlement. Is this strategy common in your country? David, why don't we start with you?
The strategy itself is common, yes. It happens. However, I would not suggest it if we are on the defendant side, if the claim is not well-founded. I would only suggest it if it is well-founded, because then, yes, it's an effective strategy. It works very well, although it shifts the burden of proof. And from that point on, you have to pay for the stamp duties yourself if you're a defendant. Up till that point, the creditor had to pay for those fees in advance. What should be noted is that if you do such a thing without legal foundation, without enough grounds, then you can be fined, but you can be penalized for fraudulent litigation.
Okay. Georgie, how about in Bulgaria? Is that a common strategy?
Exactly, almost the same as in Hungary. I just want to add towards the already given explanation is that it's very common when it comes to extrajudicial phase. When it comes to judicial phase, no one actually submits that counterclaim, because they're aware of the penalties that they can incur from submitting such a unlawful counterclaim. So in extrajudicial phase, you can see it a lot. They'll always throw at your face counterclaims or threats, but when it comes to actual court proceedings, no one actually dares.
Okay, Tadej?
I would say in Slovenia I saw cases where this tactic was used. I would also advise, like David said, if the claim is well-based, it has good solid grounds, then do it, because of course what you do, it's you save on time, save on money, because you will do it in one process. Otherwise you need to finish first this process and then again file a lawsuit, and then you lose time and money, like I said. So I would advise it if it's it has solid grounds. Otherwise no, because then you face some prosecution. You also need to bear the costs, the additional costs and everything. So yeah.
Very good. Well, that has been very interesting. Unfortunately, we still have several questions in the queue, but this is all the time we have for today. Our presenters will address the remaining questions separately by email. Before we end today's session, just a couple of quick items. First, please feel free to join the European Legal Credit and Debt Collection Forum discussion group on LinkedIn, which now has over 1,200 members. We have many international credit and collection risk professionals, and you will find our discussions and comments to be quite informative and valuable. Again, the name of the group is the European Legal, Credit, and Debt Collection Forum. I would also like to mention that the Bierens website is bierensgroup.com. That's BIERENS group.com. And as part of our webinar series, about once a quarter, we'll be profiling the credit and collection situation in another European country or two that we believe will add value to your international sales and global credit risk management needs. You'll be hearing from us in a couple of months about our next webinar on October 4th, titled Poland's Credit and Collection Environment, a Unique Work in Progress. Finally, you'll be receiving a thank you note from all of us that will contain all of the contact information of our presenters, Mr. Georgi Georgiev of Bulgaria, Mr. Tadej Francel of Slovenia, and Dr. David Mazaros of Hungary. By all means, please feel free to contact them regarding any questions, comments, or needs that you may have in their respective countries. Well, gentlemen, thank you again for a very informative session. And to everyone, thanks so much for joining us. And I'll now be ending the webinar. Thank you very much.
Thank you.
Bye.
Bye-bye now.
Bye.